In this module, we will look at co-ownership of land. Co-ownership is where two or more persons own an estate in land and as such are entitled to legal and/or equitable interests in that land. In any co-ownership situation, a trust of land will arise. Trusts. A trust is a device providing for the division of ownership of property into two components: legal title and beneficial ownership. Trusts are a creation of English law which allow legal and beneficial ownership of something, including land, to be divided. One person, the trustee, can hold the legal title to land on behalf of its true owner, the beneficiary. Whilst the trustee owns the land at law, and this fact is recorded on the Land Registry Register, the value and benefit of the land belongs to the beneficiary. The Land Registry registers only legal estates, and the proprietor is registered as the owner of a legal estate in the property. They are known as the registered proprietor. However, the register does not record the underlying ownership through use and enjoyment of the property, known as the equitable or beneficial interest. Accordingly, a potential purchaser dealing with registered proprietors can generally assume the proprietors have unlimited power to dispose of the property, unless there is a restriction or other entry in the register limiting their powers. The duty of applying for any necessary restrictions falls on the trustees, though a beneficiary under the trust may also apply. In some cases, the trustees and beneficiaries will be different people. In other cases, such as when a couple buys property to live in, they will be both trustee and beneficiary. The trustee cannot use the land for his own purposes,